You can see that there's biographies at the back of this programme, and you can see a very detailed one there for Rosemary Kayess. So if I was to introduce Rosemary Kayess, I'd be speaking for quite some time. She's achieved so much in her career. But I suppose a lot of us in the area of disability law will be very familiar with Rosemary's really important work around the drafting of the UN Convention on the Rights of Persons with Disability and the work she's done, particularly in relation to Article 24 on the right to inclusive education. So what I'm going to do is I'm going to hand you over to Rosemary, who is going to give you a presentation on the UN Convention on the Rights of Persons with Disabilities. Thank you.
Thanks, Charles. Right, my job is to give you an introduction to the Convention on the Rights of Persons with Disabilities, but to also claim back some time since you were running over a little bit from this morning's session. So my presentation will be slightly truncated and hopefully will still make sense, though I can't always promise that. So if we're going to claim back some time, I better get into the guts of it and not chat. So basically what I'm going to try and cover in my 20 to 25 minutes is look at the typology and status of CRPD, then just to give you a broad overview of the sections of the CRD that inform the interpretation, but also the major themes, and then to look at the obligations. So what are the obligations that states parties hold, and how are those obligations structured in terms of what's general and what's cross-cutting, and then talk about specific obligations, so recognised human rights and fundamental freedoms. Okay. So CRPD has come from very particular organic change in the way disability is being conceptualised. So the framework or the antecedents to CRPD is very much embedded in the way that society and, more importantly, public policy and policy discourse conceptualise disability. And the way that disability had been conceptualised, or, in many parts and in many policy areas is still conceptualised, is one around individual deficit. So impairment was seen as a deficit that meant the problems were linked to the individual's mind or body. And this was responded to by society in terms of care, treatment and protection. So programs of care, treatment and protection defined people with disability as problems to be cured or problems to be dealt with. And in many ways they were dealt with in terms of special laws and programs where people were segregated into, first rogue letter in a PowerPoint slide. We now have special education. I am not bilingual in any way whatsoever, but obviously my PowerPoint thinks I am. So special education, sheltered workshops, the ADE in the side there is Australia has this fabulous euphemism for sheltered workshops. They're called Australian Disability Enterprises. Still doesn't change what they are. Residential care, institutionalisation and guardianship, which basically excluded people with disability from participating within the society. So they were segregated off into disability-specific areas. And this resulted in not only just isolation of the individual, but social exclusion. Economic and social disadvantage would then flow from that isolation. So people with disability were not seen as part of the mainstream community. Okay, so CRPD has embraced what could be considered a contemporary approach to disability. And it's one that's based on the concept of diversity. So an approach that embraces the concept that disability is just one aspect of the human condition. Picking up on the framework that recognises the difference between impairment and disability. So it's about the recognition of that dynamic relationship of people with impairments and their social environment. So how society and the society responds to impairment has a dynamic relationship to in the way that people can be included within society. So it's about identifying and focusing on barriers to inclusion. And how the CRPD has translated this conceptualisation to disability is to place it within a human rights framework. So it takes a human rights approach where people with disability are recognised as rights bearers. And it sets up not only just a moral obligation, but a legal obligation to remove barriers. So to remove the barriers that people with disabilities experience in being included in the community, to engage both economically within the economic and the social life of the community. So what is CRPD? CRPD is a human rights treaty that was adopted by the United Nations General Assembly in 2006. Its purpose is to promote and protect the rights of persons with disability and to ensure that their rights are fulfilled. So it aims to promote respect for the inherent dignity of persons with disability, and it contains its obligations with two formal treaties. One, the Convention on the Rights of Persons with Disability, and secondly, a sister treaty, which is the optional protocol. So whilst it's related to CRPD, it is a separate legal instrument. And what the optional protocol does is it allows individual communications to the CRPD treaty body about rights violations, and it also allows the treaty body to conduct inquiry into grave or systemic violations of CRPD rights. So it's about the recognition by that particular state's party of the jurisdiction of the Committee on the Rights of Persons with Disability to both hear communications and to undertake inquiries. Now, the CRPD is a thematic instrument in the sense that it focuses on a particular population group. And that particular population group is people with disability. Now, from its very inception, so from the original resolution of the UN General Assembly, they were empowered with developing a comprehensive treaty. Now, a comprehensive treaty means that it is a hybrid treaty in that it includes various approaches, human rights approaches, and levels of obligations through rights. So it incorporates social development elements. It embeds non-discrimination. and other human rights subject matter. So it incorporates civil and political rights, and it incorporates economic, social and cultural rights. And there is some argument that it involves some new classes of rights, some third generation rights, such as communication rights that could be seen as collective rights. And it's a thematic convention that deals with the human rights concerns of a specific population group. But as we'll see in the next slide, it doesn't actually define that population group. So it's the same, it holds the same status as all other international human rights instruments. So that includes the Universal Bill of Human Rights, which incorporates the two covenants, and the Universal Declaration of Human Rights. And it also holds the same status as the other thematic instruments. And it marked the introduction of people with disability as a classified population group in international human rights. Efforts to protect, promote and fulfil human rights. Up until then, people with disability had been able to utilise the international human rights framework through the other status mechanism. So other mechanisms would have non-exhaustive lists of areas such as sex, age, socio-status, national origin and other status. So disability, even though it figured within the jurisprudence of international law, was not a recognised class of persons to be protected under international human rights law. CRPD has changed that and now has people with disability as a recognised protected class. So the rationale for behind the CRPD is that it was developed because of international concern that existing human rights treaties had failed to effectively protect the human rights of persons with disability. Even though they had always applied, human rights apply due to your humanness, but because they weren't a classified area, most of the human rights work was within programmatic areas or policy areas or the non-binding soft law of at the international level. And so it was not a coordinated or focused drive to address the human rights of persons with disability. So CRPD attempts to overcome this problem by assuring that persons with disability are now highly visible rights bearers. And so that comes that it's got a treaty body that is actively engaged in working with states parties to change the way that they legislate and their public policy. We also now have a special rapporteur that's based within the human rights charter, special procedures, which is focused on, again, working with states on how they address disability within their policies and within their legislation. It's about tailoring and applying traditional human rights to some of the specific human rights problems confronted by persons with disabilities. So the normative content that is being developed both through the treaty body but also through the special procedures, is targeted to disability, whereas there was not that level of targeting or focus on disability through either charter-based special procedures or treaty body-based international law. And one of the big things is about building capacity in human rights implementation efforts to effectively respond to the human rights of persons with disability. So it's about building capacity not just with states parties, but also building capacity within international agencies of the UN, but also in recognising through obligations within the CRPD, such as Articles 4, General Obligations, 4.3, Article 33, and Article 31, building the capacity of DPOs to engage in the implementation processes. So it's about bringing the voice of persons with disabilities into the policy discourse. What's CRPD's relationship with other instruments? CRPD is known as a specialist instrument because it's a thematic instrument. It brings to international law a specialist lens. So all other human rights instruments continue to apply to persons with disability on an equal basis with other persons. So CDOR still applies to women with disability and girls with disability. So it must be implemented in an integrated way. So all international law still applies and the general has general application. But when it comes to the specific of disability, CRPD is to be seen as the superior instrument. So CRPD, in being implemented in an integrated way, gives rise to two related implementation concepts: a twin-track approach and a mainstreaming approach. The general application instruments need to recognise the rights of, say, as in the example of CDOR, the rights of women with disability and girls, and that they might experience a different form of discrimination or a compounded experience of discrimination, and that they must recognise that throughout their instruments, throughout the instrument and the specific articles that are contained within CDOR. So generally, when we talk about CRPD rights, we don't talk about them in isolation with the other instruments, but we talk about them as an informing framework for all human rights. So it is the specialist or the specific focus on disability. And so when we're talking about intersectionality, CRPD framing of the right supersedes other framings of the right when you're talking about disability in specific. Now, CRPD is, like all international law, even though it's binding international law, it's really persuasive law. In the sense that international law is binding in terms of its relationship with the community of states. So they can be seen as being in violation, but there is no action that is taken against the state for not compliance. So it's about working with states to help them change their practice. So it's persuasive in the sense that jurisprudence will identify within a peer situation where states are violating the rights of persons with disability, but it cannot and does not have any punitive measures. Which is why it's so important to be able to identify best practice and encourage states to work towards reform. So most of its enforcement is related to the periodic review, in which the government will give a report and there will be a shadow report. And it's between the treaty body and the state's party to be able to identify areas where they will work to change their practices. This raises the importance of the shadow report and the ability for persons with disabilities and their representative organisations to be engaged in that monitoring process, both at the domestic level and at the international level. The optional protocol allows for individual complaints, but individual complaints need to be recognised within the broader international law framework. And it also needs to be recognised that there are great limitations to using individual communications as a means of law reform. It is a very long process. It is not timely at all. So there needs to be a reality of understanding that individual communications can't be seen as a means to an end, but as part of a broader advocacy process. We can go on. The target group of CRPD applies to all persons with disabilities. The CRPD very specifically does not define disability, and this was to try and ensure that states' parties didn't have any avenues to exclude certain groups. And there was big pressure during the convention negotiations to try and exclude certain groups. And so what the CRPD is, it scopes the target group that states' parties hold obligations to. It is not a defining, it's not a binding definition. And, yep. The structure of the CRPD is that it's comprised of a preamble and 50 articles. Now, the articles can be broken up into broadly 3 areas. The first is the interpretive and the cross-cutting obligations. Then you will find with Articles 10 to 30, the substantive articles that carry the normative content, and the rest are administrative articles. Okay. So the preamble, which sets out the antecedents to CRPD and informs the CRPD of not just its legal antecedents, but the areas of international concern that drove the development of CRPD. Now, the preamble is important not just because of what it contains, but also what it doesn't contain. And it very obviously leaves out 3 international instruments. 2 declaratory instruments, the 2 earlier declarations from 1971 and 1975 on mental mental retardation and the rights of persons with disability, but it also leaves out the 1991 mental illness principles. And they were very specific attempts to move away from what was seen as older frameworks and older approaches to disability. And as you can see from the table, and these slides will be available in your box because these slides will be available. Thank you, Charles. These slides will be available because I don't have time to go through them all. But essentially, as you can see there, it sets out the breakup of the convention and how it works in terms of where you find the substantive articles, where you find the interpretive articles, and what the operational articles elements do. So, just to finish up, most of the CRPD is written in straightforward, easy to understand way. So in terms of treaty interpretation, and I'm sure Kira covered this, you give the general meaning of the words. But convention negotiations are like all legislation, they're a negotiated process. There's a little bit of constructive, okay, sometimes there's a lot of constructive, how shall we say, obscurity to some of the articles, but essentially they are fairly straightforward. But they're also meant to be temporally relevant. So they need to be able to be relevant now. They need to be relevant in 50 years' time. So they can't be too bogged down in specific words and terms that time lock them. And so there needs to be a degree with which they can grow and change. You don't renegotiate treaties very easily. And so there needs to be a level of ability to give new and informed interpretations. So the jurisprudence plays a very important role. So the role that the treaty body, and to a certain extent even being informed by other areas of international law through the special rapporteur and the special procedures mechanisms, the interpretation, the jurisprudence will be developed through general comments, observations, concluding observations made about states parties' reports, and the observations that are handed down in terms of communications that are put through to the treaty body. Now, you also have to remember that this process only started in 2009, and it will always take a while for jurisprudence to filter through the system, for communications to be lodged, for states parties' reports to be received and to be reviewed by the committee. So we're in a very formative, early pupative stage of the jurisprudence of CRPD. There is a long way to go. We're only up to the 5th general comment. And so it's still an emerging body of international law, but I believe an important body of international law. How are we going? How are we going? Thank you. All right, I'll leave it there. As I said,